Tennessee is moving a bill that has a lot of immigrant families and educators on edge because it deals with immigration status and public school students. The headline is simple. A House committee advanced a measure that would require public schools to collect information about student immigration status and report it to the state education department in an aggregated, non-identifying way. But the part that makes this feel urgent is what this bill used to be and what some lawmakers have openly said they might want to do later. By the end of this video, you will have 3 things. First, a plain English explanation of what the bill actually requires right now in its amended form. Second, who is most likely to be affected, and what questions schools could realistically start asking at enrollment. And third, a practical, calm checklist for parents and school staff on what to do next without panic and without relying on rumors. Now, let me separate what we can verify from what people are guessing. What we can verify from the legislative reporting so far is that the bill originally included provisions that could have allowed districts to refuse enrollment or charge tuition to families who could not provide proof of legal status. That earlier version stalled, in part because of concerns it could put at risk more than $1.1 billion in federal education funding. What we can also verify is that the sponsor, House Majority Leader William Lamberth, told lawmakers the amended bill is, in his words, literally a data bill, and that the provisions allowing denial of enrollment or tuition were stripped out. And we can verify that opponents, including educators, immigrant advocates, and Democratic lawmakers, are worried about how the data would be collected, how it would be used later, and how it could impact families. Here is the part most people miss. Even if a bill does not directly say a school can deny enrollment, the act of asking families for immigration paperwork can change behavior fast. Families may pull kids out, stop enrolling, or avoid school services out of fear. So the impact can start long before any court case or major policy shift. So what changed exactly? In the original concept, the bill was part of a broader effort to challenge Supreme Court precedent that requires public schools to enroll children regardless of immigration status. That precedent is widely associated with the idea that K-12 public education cannot be denied to children based on immigration status. In the amended version described in the committee, the bill is presented as a requirement to gather data on how many students without legal immigration status are enrolled in taxpayer-funded schools, and then report that to the Tennessee Department of Education in a way that is aggregated and non-identifying. In plain English, the amended version is not written as a direct order to schools to turn kids away. It is written as a system for collecting numbers. Supporters argue they want reliable information to help state leaders understand costs, planning, or policy. Critics hear something else. Once a government creates a system to identify and count a group, it is easier to target that group later. And one quote that raised attention is the sponsor previously saying, after the data is gathered, we can take whatever action down the road that this body would choose to take. That does not confirm a future action, but it does confirm that some lawmakers view the data as a step that could enable future decisions. Now, let us talk about what schools might actually be asked to gather, because the details matter. The bill, as described, centers on collecting data on immigration status. That could mean, at registration, families might be asked whether a student has proof of legal status, or to provide documentation. The hard part is that immigration status is not one simple thing. There are many categories and documents, and not all families will have the same paperwork even when they are fully lawfully present. Some children may be U.S. citizens with immigrant parents. Some may be lawful permanent residents. Some may have a pending immigration application that places them in a period of authorized stay. Some may have a form of humanitarian protection. Some may be undocumented. And some may have documents that look unfamiliar to school staff. This is where people get denied in other contexts. Not because they are ineligible, but because the person reviewing the paperwork is not trained and misreads it. Educators and registrars are not immigration officers, and they are not trained to interpret complex immigration documentation. Opponents of the bill have raised that exact concern. How can educators reliably review complex documents? And what happens when they cannot? So, who is affected versus who is not? Let us put this into clear buckets. Bucket 1. Families with children already enrolled in Tennessee public schools. If the bill becomes law and districts implement new data collection processes, these families could still be affected if the school requests updated information, forms, or documents for reporting purposes. The biggest risk here is not immediate expulsion, because the amended bill does not say that. The biggest risk is confusion, fear, and unnecessary sharing of sensitive information. Bucket 2. Families enrolling a child for the first time or moving between districts. This group is most likely to encounter new questions at the front desk during registration, because enrollment is when schools collect a lot of information. If a district creates an additional step related to immigration status, that is when it would show up. Bucket 3. Mixed status families, where the child may be a U.S. citizen, but parents or guardians are not. This is very common. Even if the bill is framed around student status, the practical reality is that families may fear that any request for documents is really about the whole household. This fear can reduce enrollment and participation. This group needs clear communication from districts about what is being asked, why, and what is not being collected. Bucket 4. School staff and administrators. They are affected because they may be tasked with collecting, interpreting, and reporting sensitive data, and they may become the first point of conflict with families. Staff also face legal and ethical concerns about privacy and equal treatment. Who is likely not directly affected? Families outside Tennessee public schools, for example, private schools or homeschooling, would not be in the same reporting system. Also, if the reporting is truly aggregated and non-identifying, individual student names would not be transmitted to the state as part of the report. But here is the small detail that changes everything. Even if the state receives only aggregates, the school still has to decide how to categorize students to produce those numbers. That is where the practical burden and the fear can concentrate. Myth versus reality moment number 1. Myth. This bill means Tennessee schools can immediately deny enrollment to undocumented kids. Reality. Based on what has been reported about the amended version, the denial and tuition provisions were stripped, and the sponsor is describing it as a data collection bill. That does not automatically create a new power to deny enrollment tomorrow, but it can still change what questions are asked and what information is collected. Myth versus reality number 2. Myth. Schools can easily determine immigration status just by looking at a document. Reality. Immigration documentation can be complex, and many lawful situations involve temporary documents, receipt notices, or pending cases. Mistakes are easy if staff are not trained. Now, why is this happening? Supporters are saying they want reliable data. In many policy debates, numbers drive decisions: budgeting, staffing, legislative priorities, and political messaging. If lawmakers believe the public school system is bearing costs connected to immigration, they may want data to support future proposals. Critics worry that the data is not neutral. They point to the bill's original purpose, which included denying enrollment or charging tuition, as evidence that the data could be used to revive that approach later. Another underlying factor is the broader national debate about immigration and local services, where state-level lawmakers may push measures that test the boundaries of federal law and court precedent. There is also a procedural reason this kind of bill moves. It can be easier politically to advance a data requirement than to advance an outright denial policy. A data bill sounds administrative. It sounds like measurement, but measurement can be a first step in enforcement, depending on what happens next. Here is the part most people do not want to say out loud. Even a non-identifying aggregate report can create pressure at the local level. If districts are compared, or if funding debates start using those numbers, administrators may feel pushed to get more complete data, and that can lead to more aggressive questioning at enrollment. Let me give you 2 example scenarios so you can see how this might look in real life. These are hypothetical composite scenarios, not reports about specific families. Example scenario 1. A mother enrolls her child in a new district after moving for work. The registrar hands her the normal packet: proof of address, immunization record, birth certificate, prior transcripts. Now there is a new page, asking about immigration status documentation for the student. The mother's child was born abroad and is now in the U.S. with a pending immigration case. She has a receipt notice and a document that is unfamiliar. The registrar is unsure what to mark. The mother feels panic and leaves, saying she will come back later. The child misses the first week of school. Example scenario 2. A family has a U.S.-born child who is a citizen. The school sends home a form asking parents to report whether the student has proof of legal status and to provide certain documents. The parents worry the school is really trying to find out about them, not the child. They decide not to fill it out. They stop attending parent-teacher meetings, and they avoid requesting special education evaluations or free lunch support, even if they qualify, because they fear attention. Those scenarios illustrate the real-world consequences opponents are worried about: fear, reduced enrollment, reduced engagement, and possible harm to children. Now, let us talk about consequences in practical categories. First, enrollment delays. If new documentation is requested, families may not have it on hand. They may need time to locate passports, visas, green cards, immigration receipts, or other records. Even when a child is eligible to enroll, delays can happen. Second, privacy concerns. Families may worry about who sees the information and where it is stored. Even if the state receives only aggregate data, local schools may still retain forms or copies. Data handling practices vary by district. Third, documentation confusion. If staff misunderstand a document and misclassify a student, that can distort the data and can create unnecessary stress for the family. Fourth, chilling effects on attendance and services. The mere perception that schools are asking immigration questions can cause families to avoid school events, avoid reporting bullying, or avoid seeking help. Fifth, broader policy uncertainty. Because the bill was originally tied to an effort to challenge Supreme Court precedent, some families may fear that denial of enrollment could return in a future version or future legislation. Now, let us get to the most important part: what you can do now without panic and without making risky moves. This is general information, not legal advice. But here is a practical do this and avoid this checklist for parents and caregivers. Do this. Stay calm and keep your child in school. Do not withdraw your child from school based on headlines alone. A bill advancing is not the same as a final law, and even a final law can have implementation timelines. Do this. Ask for written policies. If a school asks for immigration-related documentation, politely ask for the request in writing, including the purpose, what specific document types are accepted, how the information will be used, and whether it is required for enrollment. Do this. Keep copies of your child's standard enrollment documents, proof of age, residency, immunization records, and prior school records are common. Keep a folder ready so you can enroll quickly if you move. Do this. Limit what you share to what is required. If you are asked for information that seems unrelated to enrollment, ask questions first. You can say, I want to understand whether this is required for enrollment and where it will be stored. Do this. Document interactions. Write down dates, names, and what was asked. If you feel pressured, you can follow up by email so there is a record. Do this. Use verified sources to track the bill. Follow the Tennessee General Assembly bill pages for HB073 and SB0836, and watch for updated text, committee actions, and floor calendars. Also, monitor your district's official announcements. Avoid this. Do not rely on social media claims that your child will be kicked out tomorrow. That kind of rumor spreads fast and causes real harm. Avoid this. Do not sign blank forms or forms you do not understand. Ask for translation support if you need it. Avoid this. Do not assume a school employee is trying to harm you. Many staff will be confused too. Stay polite, ask for clarity, and escalate respectfully to the district office if needed. Now, a separate checklist for educators and school administrators, because schools need a safe process too. Do this. Request clear guidance and training before collecting any immigration-related information. If a law requires reporting, districts should have standardized instructions and a narrow, consistent process. Do this. Minimize data collection. Collect only what is required by law and avoid storing copies of sensitive documents unless explicitly required. Do this. Protect privacy. Limit access to any collected information, document retention timelines, and ensure staff know who can view what. Do this. Communicate clearly with families. If forms are introduced, explain what is being asked, what is not being asked, and whether it affects enrollment. Avoid this. Do not make on-the-spot determinations of immigration status. If the requirement depends on categorization, districts should establish a method that does not require untrained staff to interpret complex immigration categories. Avoid this. Do not create a hostile registration environment. Enrollment should remain welcoming because the students are children and have educational needs. Here is another myth versus reality. Myth: aggregate reporting means there is no risk. Reality: aggregate reporting can reduce some risks at the state level, but it does not erase the local experience of being asked for documents, nor does it guarantee that local data handling will be perfect. So what happens next? The bill advanced out of a House Legislative Committee. That means it continues moving through the legislative process, which can include additional committees, potential amendments, and votes. On the Senate side, the full Senate reportedly passed the bill in its original form in April, but it has not yet taken up the amended form this year. And for the bill to ultimately advance to the governor's desk, the House and Senate versions would have to be reconciled. This is where things can change quickly. A bill can be amended again. Requirements can be narrowed or expanded. Implementation dates can be added. Guidance can be issued or not issued. Here are the key watch points to monitor. Watch point 1. The exact text of the amended bill. Do not rely on summaries. Read the language that describes what schools must collect, whether families can decline, and what is transmitted to the state. Watch point 2. Whether the Senate takes up the amended version, and whether there is a conference committee or reconciliation process. Watch point 3. Any statements from the Tennessee Department of Education about implementation. Agencies sometimes issue guidance about forms, reporting formats, and timelines. Watch point 4. Federal funding concerns. The bill previously raised concerns about jeopardizing federal education funding. If that concern resurfaces in official debates, it can shape amendments. Watch point 5. Any legal challenges. Because the bill is connected to a broader effort to test Supreme Court precedent, it is possible, not guaranteed, that lawsuits or federal scrutiny could arise. If that happens, it can delay implementation and change what districts do. And watch point 6. Local district behavior. Even before anything is final, some districts might prepare new forms or procedures. Others might wait for official guidance. If your district sends a new form home, treat that as a signal to ask questions and get clarity. Now let us recap in a calm, simple way. 1. A Tennessee bill known as HB073 and SB0836 advanced in a House committee, and it deals with collecting data on student immigration status in public schools. 2. The bill originally included provisions that could have allowed denial of enrollment or charging tuition, but those provisions were reportedly stripped in the amended version described as a data bill. 3. Even as a data bill, it can affect families through paperwork requests, privacy concerns, and fear that discourages enrollment and participation. 4. Educators are caught in the middle, because immigration documentation can be complex, and staff are not trained to make legal determinations. 5. The next steps include House and Senate reconciliation and any agency guidance, so the exact requirements can still change. If you are a parent, the goal is not to panic. The goal is to stay enrolled, stay informed through verified sources, and respond to any new paperwork requests by asking for clear, written explanations. If you are an educator or administrator, the goal is to protect kids, follow the law as written, minimize sensitive data collection, and communicate clearly. If you want, tell me in the comments what district you are in and what, if anything, your school has already asked for during enrollment, and I will compile patterns for a follow-up video. And if you want ongoing updates explained in plain English without fear-mongering, subscribe and turn on notifications so you do not miss the next breakdown when the bill moves again.